laws that we've got. All right, so let's go over this a little bit and talk about the historical review. So, I don't want this to be a history class, but it is obviously going to start out with the Declaration of Independence in 1776, and that was really the document that set us, the 13 colonies, free from England, okay? So then in 1878, we have the Constitution of the United States. Now, the Constitution is basically the supreme law. This is the law that we govern the body of the federal laws and things like that. Then in 1791, we had the Bill of Rights. The Bill of Rights is a collective name for the first 10 amendments to the Constitution. All right, now we are not going to go over what the Bill of Rights basically are, but we all understand the Second Amendment, especially you handgun advocates. We all understand the Fifth Amendment about not being able to perjure yourself or have to testify. So if you're interested in what the Bill of Rights are, the first 10 amendments, you can simply Google, 10 amendments or the Bill of Rights, and that will give you a list. If you've never done it, I would suggest you go out and look at it. It's very interesting to see some of the issues that and how they fall, and what you might think is logical may not be covered by some stuff. Then we progress a little farther, and we get into 1857. We get into this thing called the Dred Scott case, the Dred Scott decision. All right, the Dred Scott decision basically was the Supreme Court, where it said African Americans, whether they were enslaved or free, could not be American citizens and therefore had no standing to sue in federal court. Basically, Dred Scott was a freed slave. He tried to sue because they said he was actually in servitude, and he said he wasn't, so they went to Supreme Court. And the decision that came out of it basically said that as an African American, he had no right because he was not a citizen, okay? Then in 1865, we have the 13th Amendment, which is not in the Bill of Rights, but the 13th Amendment, which basically abolished slavery and any kind of involuntary servitude, except as a punishment for crime. Because basically, if you think about it, when someone's in prison, that's what it is. It's a involuntary servitude. They are serving penalty, but the 13th Amendment doesn't cover them because that is an exemption. So it abolishes slavery and any kind of involuntary servitude except as a punishment of crime. So then we roll around to 1866, and we have what is the very first major step. It's called the Civil Rights Act of 1866. This was the first United States federal law to define what a U.S. citizen really was. And it affirms that all citizens are equally protected by the law. This basically now kind of acts, or actually, what's the word I'm looking for? You know what I'm talking about, David. It goes against, I just completely lost my train of thought because I was too busy trying to think of something else. The Dred Scott, it overturned, thank you, it overturns the Dred Scott decision, where it says that African Americans aren't citizens. So in 1866, the Civil Rights Act says, yes, all, now that we've had the 13th Amendment where we abolish slavery, this law actually now makes all of the people that were serving as involuntary servitude or slavery are now U.S. citizens. And as far as the fair housing goes, the big key here is you need to remember this is the very first act that says it's illegal to discriminate housing issues based on race. And race is the sole classification that they define here. So you cannot discriminate any housing based on race. That's the Civil Rights Act of 1866. Well, then in their infinite wisdom in 1896, what we end up with is what we call the Plessy versus Ferguson. And you guys, some of you are young enough in here to remember high school. Hell, I barely remember yesterday. Plessy versus Ferguson is the one that gave us the separate but equal mantra that, if you guys remember, it was okay to have segregated amenities and items as long as they were equal. So you could have a colored water fountain and a white water fountain as long as they were equal, that in and of itself on the face was not discrimination. So separate but equal was okay. All right. Now, that rolls for a number of years, and we lived under that rule of separate but equal. Obviously, we understand now, looking back, that there is no way, and they weren't equal. I mean, I've seen pictures of facilities that were governed for what they called the colored people then versus the white people, and there was no way in hell that those were equal. But that was kind of what the mantra we lived on. Then in 1954, you have the Brown versus the Board of Education, and this was Topeka, Kansas, where the court declared the state laws establishing separate public schools for black and white students to be unconstitutional. When it came to education, there is no way that they could have separate and equal. So they actually merged them back, and that's the Brown versus Board of Education, and it happened in Topeka, Kansas, where they said it's inherently impossible to have separate but equal. It was unconstitutional. Then in 1968, we have the Civil Rights Act of 1968. Now, this is where it kind of gets confusing. You actually have a Civil Rights Act of 66, which basically said it was illegal to discriminate. The Civil Rights Act of 1968 specifically mentions housing. Matter of fact, Title 8 of the Civil Rights Act of 1968 actually goes on to become the Fair Housing Clause. All right? So you've got the Civil Rights Act of 1966, but the one of 68 is the one that we're important with, because that's the one that says becomes the Fair Housing Clause. And they actually added 3 more clauses here. The Supreme Court, that's who they is, all right? The Supreme Court reaffirmed that it was illegal to discriminate on race. And then they added 3 more because they said it was inherently indistinguishable between a person's race, their color, their religion, and their national origin. Now, I am not so sure about religion anymore, because it seems to be, you've got Americans, or what you would call Caucasians, that are Muslim. You have got people that are Oriental that or Asian that are Christian. We have got people that are Buddhist that are not Asian. So I think it is inherently, you can separate out or distinguish anyway a person's difference. The Supreme Court said it's not. So basically what you have is the Civil Rights Act of 1968 come about, and they've got now 4 protected classes. You've got race, color, religion, national origin. Well, there was a court case in 1968 that led into this. It was called the Jones versus Alfred H. Mayer company, Jones versus Mayer. And basically, here's what happened. Mayer, M-A-Y-E-R, suggested or determined he was not going to sell his house to a potential buyer for the sole purpose because the guy was black. All right? He said, I'm not going to sell to you because it was black. Well, obviously Jones said that that's a violation and sued, and it got kicked all the way back up to the Supreme Court. And the Supreme Court, the attorney for Jones actually went in front of the Supreme Court and said, hey, look, Your Honor, you solved this case 102 years ago in 1866 that said it was illegal to do this. So that was the court case that kind of gave impotence to the Civil Rights Act of 1968, and where they added the other 3 protected classes. Now, there's a couple other court cases you guys can go in and look at that are very interesting. There was one court case, and it escapes me now, but basically where the Homeowners Association said that they were not allowed to sell to any coloreds or Mongolian. I don't know why that one was chose out of all of them, but that's actually what the Homeowners Association said. And that was the grounds for this particular case, where they tried to block another person. Okay, let me back up. I'm sorry. I'm trying to go too fast for you because I'm throwing it all in. Basically, a gentleman who was black bought a house in the housing area. A guy that lived a distance away, like 8 to 10 blocks away, filed suit saying that it violated the homeowners associations for this guy to hold the house because he was black, and the HOA said no coloreds or Mongolians. All right. So when it went to court, basically the court came back and said that HOA on the face was not discriminatory because that was a private issue. But if someone tried to sue, much like this guy was, in court, then it became an issue of race, and that was protected, and they couldn't block the sale, which was already too late because the guy already owned the house. All right? So you might want to look that court case up. It's pretty interesting if you want to sit and read all of that about how some idiot 10 blocks away, which basically is a mile away, tried to get this guy out based on the HOA documents. Now, there's a buddy of mine that actually collects signatures. Real big into it. I mean, he's got a bunch of like George Washington's signature and, Babe Ruth's and documents and things like that. And he actually has a homeowners association document from here in Indianapolis on the Near East Side in the 20s, which basically says the same thing. And that's one of the reasons why he keeps it, because he thinks it's historical significance. Basically, it says that they're not allowed to sell to any colored people. So, it's amazing the stupidity that we had in place at that time. So then in 1974, we have the Housing and Community Development Act, which created the Section 8 housing. So in 74 is when the Section 8 came about. But in that Section 8, they talked about discrimination, but they added sex as the 5th protected class. Now, what they mean here is gender, male or female, okay? We aren't, at this time, they weren't concentrating on sexual orientation. So that's not what it means here. When they added sex in 1974, they mean the gender, not orientation. And then finally in 88, they amended the Fair Housing Act to add the last two classes that we have called the disability and familial status. Okay? So what you have now are 7 protected classes, and I don't want to beat your head on the rock, but I'm sure you all guys know race, color, religion, national origin, sex, familial status, and disability are our 7 protected classes. Then in one more act in 1990, they added the ADA, the Americans with Disability Act. The Americans with Disability Act, basically there are 5 titles to that, or sections. And Title I deals with an employer making his place reasonably achievable for his employees with handicap. And then Title III is the other one that we deal with, and that is access to public goods and services. So that's the elevators and the ramps up instead of stairs. Title II deals with government agencies. 4 deals with the communications, most notably like the TTD. And then Title V is a miscellaneous section, basically concentrates a lot on the anti-retaliation of people doing this. So what you have now is those protected there. Now, there are some exemptions to the fair housing, all right? And you guys need to be aware of this. There's an owner-occupied building with no more than 4 units, as long as the person lives in one of the units. They call this euphemistically the Mrs. Murphy exemption. So if you have a 4-unit and you live in one of the units, potentially you might be able to get away with some of these issues. Now, there are some other things in here that you got to fall on. One is an individual, another exemption is if an individual owner does not own more than 3 such single-family homes at one time. All right? So who's going to own more than 3 houses at one time? Anybody? Exactly. Landlords. Landlords. So if you're a landlord and you're making a living out of this, or in a property management company, you need to understand this exemption doesn't include you. So this deals with like the one person mom and pop, okay? And then the last exemption is, what is it, housing? Wait a second, where'd we go? We lost our chart. The third exemption is going to be housings operated by organizations and private clubs that limit occupancy to members, right? Got it? Clear as mud. Basically what that's saying is, let's say the Fraternal Order of Eagles owns a house and they only want to sell it to a member of the Fraternal Order of Eagles. That is fine as long as becoming a member of the Fraternal Order of Eagles is not discriminatory in nature. So basically what they say is, hey, we only sell to or rent to other members of the FOE Troop 106. If you want to be considered for the sale, just go join the FOE. That's legal, okay? As long as they don't allow, as long as it's not discriminatory. Now, we've touched on the evolution of the protected classes. Remember, it starts with just race in 1866. Then in 1968, they had 3 more. They reaffirmed race. They had color, religion, and national origin. In 74, the Housing and Community Development Act, we add sex, meaning gender. And then in 88, we amend the Fair Housing Act to add disability and familial status, which is families, all right? Now, the Fair Housing Act's discriminatory housing practices. It was outlawed because of race, color, religion, national origin. You cannot refuse to sell or rent a dwelling, discriminate on any of the terms or conditions. You can't engage in any conduct which makes unavailable or denies dwellings based on any of these. You can't advertise that indicates a preference. You can't represent that the dwelling is not available when in fact it is. And don't engage in block busting, all right? So let's go back and cover those real quick. What it's saying is, you can't refuse to sell or rent a dwelling based on one of the 7 protected classes, okay? You can't discriminate on terms or conditions or privileges based on one of the 7 protected classes. So you can't say, well, if you're a white person, you get access to the laundry room, but if you're, not, you don't. That is not only stupid as hell, you can't discriminate on terms. You can't engage in any conduct which makes unavailable or denies dwelling. So you don't, not only can you not say it's not for sale, you can't engage in any other activities. You can't advertise for a preference. So you can't put an ad out that says so-and-so and so-and-so, white couple only, all right? And you cannot represent the dwelling is not available. So if someone comes in and they don't meet what you want, you can't say, oh, well, sorry, that rental's not available. And then when the next white male comes in, I would say, oh, yeah, sure, let's go look at it. That's obviously a violation as well. I'm trying to follow my outline. This is kind of new that I'm doing rather than just audio. Block busting. Can't engage in block busting. Are we all familiar with what block busting is? Block busting is one of the violations of the Fair Housing Clause. It used to be called panic selling or the white flight. Unscrupulous investors would go into a neighborhood, predominantly white, and say, hey, your house values are going to go down because the Blue Man Group is moving in, and that's going to lower your values, so you should sell your house today before it gets bad. Oh, and by the way, I just happen to have cash on me. That's block busting. Don't engage in any block busting at all. Now, what are the HUD regulations? Well, now here's the problem. There are many, many HUD regulations. And I want you to go to www.fhpa.gov fairhousing.com. That will give you a link to all of the regulations. This is only a 2-hour course, and I certainly don't want to read all of the regulations to you. Most of the big ones we're going to cover in here, or most of them that you have heard before. But if you want to see them in print and maybe print out some, I would suggest you go to fairhousing.com. All right. Now, HUD actually defers to states that have their own fair housing. Indiana has such a fair housing office. Matter of fact, it's called the Indianapolis Office of Fair Housing and Equal Rights, FHEO, Fair Housing and Equal Rights. Its responsibility is to investigate any housing discriminations under the complaints of the Federal Fair Housing Act. Now, write this down. Here's a phone number. It's 317, obviously area code 957-7332. All right? That is the State Fair Housing Office. Now, and we're going to talk about this down the road. When HUD gets a complaint, they would defer that to the state office if there is a state office. Since we are all in Indiana and Indiana licensees, it is important to understand that Indiana does have their own fair housing office. I think it's right downtown in the federal, the Minton K Park building. If you need to go down there, but if you want to call, once again, 957-7332. All right? Any questions? That's kind of like the overview. We're going to get into some more stuff. We're going to talk basically about some of the amendments and specific classes. All right?